Have you ever wondered how the global community tackles threats that don't respect borders, like those posed by terrorist organizations? It is a complex challenge that demands a sophisticated and coordinated international response. International law addresses terrorist organizations not through a single overarching statute, but through a comprehensive and evolving framework of international conventions, multilateral treaties, and United Nations Security Council resolutions. This legal mosaic aims to disrupt their activities, deny them safe havens, and bring perpetrators to justice. The reason for this multifaceted approach lies in the very nature of international law and state sovereignty. Unlike national legal systems, there is no single global legislature to enact a unified law against terrorism. Furthermore, a universally agreed-upon definition of terrorism has proven elusive among states, primarily due to differing political perspectives and national interests. As a result, international legal instruments tend to focus on criminalizing specific acts associated with terrorism, such as aircraft hijacking, hostage-taking, or the financing of terrorism, rather than defining and outlawing the organizations themselves. The United Nations plays a crucial role, particularly through its Security Council, which can issue binding resolutions requiring member states to undertake specific measures, including sanctions against designated terrorist groups or individuals. These resolutions leverage the collective will of nations to confront shared threats. For nations, this means incorporating these international obligations into their domestic legal systems. States are expected to enact laws that criminalize the specific acts outlined in the conventions and resolutions, facilitate the extradition of suspected terrorists, and cooperate on matters like intelligence sharing and mutual legal assistance. This domestic implementation is critical because international law largely relies on individual states to enforce its provisions within their own jurisdictions. Two key mechanisms highlight this evolving strategy. Firstly, the existence of 12 universal legal instruments, often called sectoral conventions, target specific types of terrorist acts. For example, the International Convention for the Suppression of the Financing of Terrorism criminalizes providing funds for such acts. Secondly, the United Nations Security Council utilizes a listing process, notably for groups like Al-Qaeda and ISIS, which mandates that member states freeze assets, impose travel bans, and prevent arms supplies to these listed entities. This proactive measure underlines a commitment to financial and operational disruption. Another powerful concept at play here is universal jurisdiction, which allows any state to prosecute individuals for certain grave international crimes, regardless of where the crime occurred or the nationality of the perpetrator or victim, ensuring that such egregious acts do not go unpunished. Ultimately, while the absence of a simple, all-encompassing international law against terrorism presents challenges, the existing framework provides a robust and adaptable set of tools. By focusing on international cooperation, criminalizing specific acts, and denying resources and sanctuary, this legal structure actively works to mitigate the global threat posed by terrorist organizations and enhances collective security for all.